Good afternoon, everybody. You're very welcome to this, our second webinar in our series of multi-unit developments training over the course of Wednesdays at lunchtime. We have a large number of attendees logging in at the moment as we speak, so we'll allow some time for people to join us. David Rouse is my name, multi-units developments advisor with the Housing Agency. A reminder of the remaining sessions in our program of events coming up. Today, 21st of July, is service charges and debt collection. Next Wednesday, the 28th, again at 12:30 p.m, MUD financial management and OMC accounts. On the 4th of August, Wednesday, the 4th of August, that is, company law for OMCs. On Wednesday, the 11th of August, the role of the management agent and the Property Services Regulatory Authority. And on Wednesday, the 18th of August, again at 12:30 p.m. lunchtime slot, we will address the topic of sinking funds. A little bit about the Housing Agency for those of you who may not have been with us last week. Our mission, our aim is to promote the building of sustainable communities, and the full title of the agency is the Housing and Sustainable Communities Agency. We work with the Department of Housing, Local Government and Heritage, with local authorities, with approved housing bodies and with stakeholders across the housing sector in the promotion of sustainable communities. A quick outline of our intended timetable for today. So we will hand over to our presenter, who I'll introduce shortly, at 12:40. We will have the technical presentation for about 40-45 minutes thereabouts, and we will have time for a Q&A, and we'll aim to have you back to work, or if you happen to be on holidays, back to your holidays at about 1:45, give or take. A reminder that if you missed last week's session 1 on the Multi-Units Development Act, you can access that on our YouTube page. So if you just go to YouTube and put in Housing Agency and go to videos, you'll find it there in the top left corner. It's the latest recording to be made available. A reminder, please, if you haven't already registered for the remaining 4 webinars in the program, please do so via our website. Registration for today is for today's session. In other words, if you want to attend the subsequent sessions, you need to go and register individually for those sessions. A reminder that details on certificates of attendance are available on our webpage, again, housingagency.ie. We would say that the content and the information and the guidance being conveyed to you today is information of a general nature in relation to specific cases and circumstances in your own multi-unit development or OMC. You should seek the advice of a property or legal professional as appropriate to the particular issues. But today we will provide signposts and directions in relation to service charges and debt collection that will be informative and educational for you all. We would also say that there is a crossover or common ground between the subjects of the various presentations. And so while a particular topic might be touched upon today, it may be addressed in great detail, for example, in relation to company law or in relation to sinking funds at subsequent sessions. So I know we have received a number of questions in advance on particular topics, and many of those will be addressed in subsequent sessions. We would remind you that today's event is being recorded for future use. In other words, we're going to put it up on YouTube channel so you can watch it back. Again, a reminder of where on our website you can register for the subsequent sessions. That's the page, housingagency.ie, and news and events, and you'll find the pink text is where you can click to register. Please use the questions and answer function for questions to our presenter, and please use the chat function if you have any problems in relation to the technology, so sound or vision. My colleagues Tara Doyle and Sarah Kennedy are available monitoring in the background for any of your problems with the technology, but hopefully all will be well and we will have a clear presentation. A reminder that the slides will be provided to attendees by email later on in the coming days, as will a link to the recording. So with all the housekeeping out of the way, I'll introduce our presenter this afternoon. Our presenter is Jason Hart, partner and head of debt recovery with Mason, Hayes and Curran. Jason is a qualified solicitor, and together with his team, he advises on collection litigation, enforcement of judgment for many of the firm's clients, including OMCs and management agents. He has experience in property-related litigation, particularly the enforcement of security taken by creditors and the forced sale of land. Jason also provides training to OMCs and other stakeholders in the housing sector on credit and debtor management policy. So with that, I will ask Jason to, I'll stop sharing my screen. I will ask Jason to unmute himself and hand over to Jason. Thank you very much.
Thank you, David. With that, I will share my screen too. Alone, we can do so little. Together, we can do so much. Those are the words of the American author and advocate, Helen Keller. Now, I don't think she had multi-unit developments in mind when she said them, but there's no doubt that without successfully collecting service charges, an OMC can do rather little. But if those service charges can be collected, there are so many things, so much that the OMC can do. Provide things like gardening, refuse collection, insurance, and so many other things that create and maintain communities. Obviously, though, to pay for services in any development, the OMC has to levy an annual service charge on the owners of the properties in that development. As David said, today I'm going to talk about the collection of those service charges. And I'm going to cover, firstly, how and why the service charges arise. Secondly, any alternative options that are available to OMCs. Thirdly, going legal, that is suing an owner in a development and enforcing any judgment. And finally, we'll have a glance at other jurisdictions and the equivalent of OMCs there in comparison to Ireland. Before we do that, though, I'd like just to ask you about your own involvement in OMCs. And David is going to run a poll that asks you to tell us maybe what capacity you're interested in or involved with OMCs.
Thanks, Jason. Hopefully everyone can see that poll running now. And while that's running, just in the context of your PowerPoint, Jason, you might hit it to presenter view when we go back to finish the poll.
Absolutely.
Great, thanks. So we'll run that poll for another 10 or 15 seconds. It should be said that the poll is completely anonymous, so attendees can feel free to participate. There'll be no record of your input into the poll. So I think we've got nearly 80% of our attendees voting.
We do indeed, and there's quite a high number, I suppose, of directors of OMCs, and you'll have much more of an involvement, I suppose, with the actual day-to-day bread and butter collection of the service charges.
I'll finish the poll now. Let's run for about a minute. I'll share the results. So hopefully you can see the results there.
I can indeed, yeah. Very good. Mostly directors, and we have a lot of agents too. So as we say, people that are very much involved in the day-to-day collection.
Okay, I'll take that down and back over to you, Jason. Thanks a million.
Sorry, just give me Apologies, I'm just trying to run the slideshow.
You go down to the bottom right of your screen and to the slider percentage, and just to the left of that, if you hit that easel button down to the bottom right of your screen. That's it.
Oh,
that's it. Yep. Perfect.
So guys, how and why service charges actually arise? Well, service charges are payable by the owners of units in a development, usually annually, following the approval of a budget for that development that would have been set at a general meeting by the owners. The requirement that the approval of the charge at the general meeting comes from the Multi-Unit Development Act of 2011. There was a session last week, I'm sure that many of you were at to discuss that act in detail. In your own time though, it's well worth reading sections 18 to 22 that deal with service charges and indeed sinking funds and their collection. For me, the transparency that the approval of a charge that's levied on any given owner in a development by a voting majority of all of the other owners is really important. I say that because there are so many debts that people have to pay in their lives that they've no hand, act, or part in setting. Things like insurance premium, property tax, they come to mind. But owners in multi-unit developments, they can assess the level and the costs of the services that they're willing to pay for and decide upon the charges to pay those. For me, most of the issues then that arise regarding the fixing of the service charge should be trashed out at general meetings. The owner needs to see the bang that he's getting for his buck and how the money that he spends benefits the environment. That's an environment where he lives. And I suppose since COVID, it's an environment where we spend most of our time. Now, I know it's up to the owners to actually attend those meetings, and you guys can't compel them to do so. But at those meetings, it's crucial that really focused information is given to the owners about the service charges. They should know how the service charges create good living conditions, how they make the place where they live safe, and how those service charges actually help create and indeed maintain a community. Our host today, the Housing Agency, together with Fluid Housing, who, as many of you know, are the largest approved housing body in the country, they commissioned an independent report back in 2019, and it looked at the performance of OMCs in Ireland. The report's available on the Housing Agency's website. I wanted to bring it to your attention for what it says about the collection of service charges. It makes the point that collection of service charges is one of the most important, but also one of the most difficult functions of the OMC. As many of you know, when a service charge is not paid by one or more of the members in a multi-unit development, other owners then end up being faced with having to pay for that person's default, possibly, and often probably, through higher service charges. And if a smaller amount of paying people end up with higher charges, that causes people who are previously compliant to stop paying. You can quickly see how that becomes a vicious circle. The agency's report reminds us too that OMCs aren't like traditional trading companies who might supply goods or supply services, and they can do so. They can expand, I suppose, their customer base by simply increasing sales. The OMC, on the other hand, has a fixed customer base, the only people that it can collect service charge from are the unit owners in the development. That means then that collections are arguably even more important for an OMC than a traditional trading company. And default is, I think, then a bigger problem for OMCs than for traditional trading companies. In the report, there was an analysis of some 50 or so multi-unit developments across small, medium, and large ones. And the report concluded that the overall average debt ran at any given year end at 52% of the income that the OMC was to collect, that it would have used for its annual running costs. I reckon there's very few companies that trade that would be able to carry that kind of level of slow paying or non-paying customer. The report concluded that there was a culture of non-payment of service charges in Ireland, with the knock-on effect that it's extremely difficult for the OMC to provide the services for which it exists. In a lot of cases, residents, owners in multi-unit developments don't take service charge debt as seriously as they might take debt to utility companies, money they owe to their banks or to revenue. That's a culture that needs to change. Many residents or people involved in OMCs will tell me that the problem, to some extent, is the legal system. As I said, I'm going to discuss litigation, the judgment, and the enforcement system in Ireland in just a few minutes. And as a solicitor, I accept that there are some features of the system that makes it unattractive for OMCs. Personally, though, even though debt collection keeps me in a job, I don't believe it should be that litigation should be the first port of call for an OMC to recover a service charge. So you might ask, well, what can the OMC do? There are alternatives to debt collection litigation, and I've listed some there on the screen. Let's look at them. An OMC can withdraw services. For example, denial of gate fob access to the owner who isn't paying their service charges, clamping a car, or access to a refuse area. But it's really important that the right to do that is reserved to the OMC in the lease with the unit owner, and indeed that it's there in any credit or debt collection, debt management policy that the OMC operates. Those kind of policies should be discussed and approved at AGM by all residents that are present and voting. That said, though, I've always found that the withdrawal of services such as utilities or parking has been practically and legally troublesome. For example, if you share bins, it's very hard to exclude one particular unit owner access to those bins. My advice when you are seeking to withdraw a service to a non-paying owner, make absolutely sure that notice is served and given to that owner, as in demands that they pay the arrears that they owe, and that if the arrears aren't paid, what the consequences are before you take any of those kind of actions. Second one listed there is the loss of voting rights at an AGM or other meetings of the residents. Obviously, that's simpler to implement, and particularly so with the electronic voting that we have at AGMs since the COVID pandemic began. I find, though, it rarely operates as an effective sanction. Obviously, it prevents the debtor owner driving change within the OMC, but that resident rarely cared, given that he didn't pay his service charges, what way votes might have gone anyway. The third thing that I've listed there that OMCs can do is add interest to service charge debt, and that's frequently found as a right in leases. Obviously, it has to be present as a right if you are going to do it, and it should also be in the debt management policy that the OMC will operate. I found, though, that in court cases where they are defended, even where the OMC has the right to levy contractual interest, that judges dislike adding it to the debt, even after you might win in court in proving that the particular owner must pay the service charges. The judge doesn't want to penalise the non-paying owner, but by not penalising the non-paying one, they're ultimately penalising the compliant ones. The identification of non-paying owners is something that's talked about a bit. For example, OMCs might want to publish a list of house or apartment numbers where no payment has been received for the previous year. Solicitors, including me, are going to tell you that you can't do that for GDPR reasons. It is people's personal data, and you're making it public. And even if there was, say, a consent in a lease to do that, it's still a couple of years on wouldn't comply with the GDPR protections that the owner would have. I think ultimately you'd have a better chance of proving it fits into the legitimate interest exception to GDPR, but I'm awaiting the first reported case where that's been ran as a defence in any given court. And if any of you are running it, please do let me know. The final one that I list there is the collection of the service charges from the debtor owner when he seeks to sell his unit in the development. That is often the best way of collecting long-time arrears of service charges, simply because the OMC will withhold the information from any purchaser's solicitor unless and until the service charges is paid or there's a solicitor's undertaking to pay them. It's a proven way of collecting arrears, but it's limited to situations where the debtor chooses to sell. So, why issue debt collection proceedings? Well, if the OMC or the managing agent issues his invoices and escalates them, there's usually an escalation cycle in any given year. It comes back then to the board of the OMC to decide whether you legally pursue certain debtors for non-payment of service charge arrears. As a lawyer, the main problem I see with using litigation as a means to collect the service charge arrears is that service charges are a recurring debt annually, but judgment can only be obtained for a single year or indeed a series of years in the past. You could contrast that, say, with the bank loan, where if there's default, the bank isn't going to sue you just for the arrears that you missed. Rather, it'll call in or accelerate the entire amount that you owe and simply include it all in one set of legal proceedings. That's not possible, of course, though, for service charges. That's why by the time you've got judgment for the current year's service charge debt, it's come around again, and it's time for that defaulting owner to pay the next year's. And then you're asking yourself, do you go through the cycle all over again? People in OMCs then say that there's often only one winner out of a decision to litigate, and that's the lawyer. So we ask the question, or the OMC is entitled to ask the question, why sue? Well, the OMC should think carefully about the decision to litigate and ask itself before it sues a given debtor, is there good reason to do so? For me, then, there's two key reasons why you might do so. You do it based on actual or expected monetary recovery from an owner who you believe has the means to pay. That could be a person that depends upon their good credit status. They might have their own business, or they might work in a regulated sector where financial fitness and probity are monitored. And they might want to avoid a debt, to avoid a judgment. And on that basis, there might be a strong possibility of successful enforcement against them if they have reason or a known or a suspected asset base. The other good reason to issue proceedings against non-compliant debtors is, of course, the publicity of doing so and keeping other payers compliant. You'll often have a case where a certain owner might tell other people in the development that the OMC doesn't have the will or the budget to sue them. And then if the OMC does in fact do that, you're going to hope that it has both the will and the budget, that word will get around, and that those non-compliant will indeed become compliant, and those who are compliant will stay so. If you are going to sue for that kind of deterrence or publicity reasons, I'd always advise an OMC to critically assess how many lawsuits that might need, and to zone in, laser in specifically on who should be sued, what the arrears level should be, before you do that when you want to get word around. Before we issue legal proceedings then, we got to check that the necessary elements to prove a debt are in place. Obviously, the responsibility is on the unit owners to pay service charges, and the entitlement of the OMC to collect them comes from the conveyancing documents that people entered into when they buy the unit. Since 2011, though, those leases and the contractual provisions are backed up by statutory obligations that are set out in the MUD Act. As I said, Section 18 particularly. As a solicitor then, what do we look for from an OMC when an OMC wishes to issue proceedings as against any given owner? I've set out a list there on the screen, and your solicitor is going to ask for all of these documents and information when you make a decision to issue legal proceedings against non-paying owners. First of all, you look for the copy lease with the debtor owner, and that should show the covenant to pay annual service charges. Statement of account and copy invoices that were sent, usually by a managing agent, and I know we've got quite a few in the audience today, sent to the owner debtor. As a solicitor, you'd look for evidence of the invoicing of the annual service charge that should be in compliance with the budget agreed at the relevant AGM or EGM, including a copy of the annual accounts of the OMC for that particular year. I'd also ask any given OMC for its debt management policy. That should show the terms that it gives owners. Usually there'll be an invoicing cycle earlier in the year, usually often in January, that sets out how long, what length of time is given to an owner to pay. The policy too obviously should set out the payment obligation and give information concerning the payment methods that the OMC utilizes and the managing agency utilizes, I suppose, to make it as easy as possible for owners to pay over their service charges. The policy itself, as I say, should include any terms in relation to the withdrawal of services that the OMC seeks to rely upon. I always find that it assists in fending off defences if the rights of the OMC are discussed and articulated at EGMs, and if members have voted on them, and that they're enshrined in documents that are available to pretty much everybody in the OMC. As solicitors, we'd also look for any demand letters that were sent by the OMC or by the agents, and any follow-up correspondence or responses that the debtor made. It's important that we would get up-to-date information on the address and contact details of the debtor. It's frequently a case that an owner of a unit in any given development might not actually reside there and have it rented. And so if we're to issue proceedings, we can't simply serve them on the unit itself. We've got to actually serve the owner wherever the owner is based. Assuming then that the decision to issue collection proceedings is made, well, where would you do that? There's 3 court jurisdictions in Ireland where legal proceedings for debt recovery can be started. There's the district court that deals with claims that are below 15,000 euros in amount. I think actually that most OMC claims for service charges, if we take the annual service charge, maybe between 1,000 euros and 2,000 euros per annum, most claims will take place in the district court. The document that starts a debt collection lawsuit in a district court is called a claim notice. After that, then, you've got the circuit court that deals with claims from 15,000 euros or just over 15,000 to 75,000 euros. A circuit court sits, there's at least one in every county in the country, whereas the district court, as slide above there, it sits in practically every town in Ireland. The document that commences a debt collection claim in the district court is called a civil bill. Finally, then, the third court where debt collection legal proceedings can be started is the High Court, which handles claims in excess of 75,000 euros. That sits in the Four Courts complex in Dublin. But OMC work, particularly residential OMC work, tends not to be a feature of the High Court, simply because it's rare that the level of service charges will actually get that high. The document then to start a High Court claim is called a summary summons. As solicitors, and I'm sure as people involved in collection, we divide the debtors, owner debtors, into people who can pay and people who won't pay. So I say that because once a summons issues out of a relevant court, it can go down one or two paths. You can have a default judgment or you can have a defended case. And with default judgments, that usually happens where the debtor makes no response or just refuses to engage with the legal proceedings. And the creditor then is entitled to seek judgment in the office. That means that there's no court hearing required, that the OMC or a director of the OMC will swear what we call an affidavit of debt, setting out how much is due to the OMC. That's lodged by the solicitor for the owner management company with other documents, simply with the court office, and the court office issues judgment. As solicitors, we tend to refer to that as getting judgment in the office as opposed to going before a judge. And that's frequently the stance or the attitude taken by those who can't pay. They simply won't engage with the proceedings or won't defend them, even if publicly or privately they admit the debt, they know they owe the debt to the OMC. The second way then that a case can go towards a defended hearing. And that happens when a debtor owner defends the legal proceedings by lodging a document called an appearance. That's a one-page notice that effectively tells both the court and the solicitors for the OMC that the debtor is going to defend the proceedings. He or she has got to set out his or her reasons for defending the case in writing. And after that, the solicitor liaising it with the OMC will decide whether to set the case down for hearing or not. Obviously, the cost of legal action will be a key determinant in deciding that, but it's not the only factor, obviously, for deciding whether the OMC should pursue the debtor by way of a full trial. In assessing that, the OMC should ask, well, does the owner or debtor have a valid claim? Was there any shortcoming in how he was treated in what he says in his defense, in terms maybe of service provision? Were all the notices that we, the OMC, issued properly served on them? Or does the debtor have any grounds for saying that he was unfairly singled out? These kind of decisions, though, should be considered at the outset, and OMCs should really think about, is the reward of winning the case sufficient to justify the risk in taking it? Whenever an OMC says back to me, well, I don't know, I'm not sure, I urge them to do more homework before making a decision to sue that particular debtor. How long then do the cases take, depending upon which cycle they go? Well, if a district court claim isn't defended, then the creditor should be in a position to get a default judgment. It takes about 6 to 8 weeks after service of the claim notice on the debtor. Some courts, though, they're reluctant to mark judgment if the OMC claims interest in the claim notice. They might put it back to the OMC or the solicitor to say, look, if you want interest, you've got to make an application for that before a judge. And generally, that'll add 2 to 3 months on top of the 6 to 8 weeks. For that reason, then, I might often advise OMC directors that they should consider waiving any interest claimed in the summons if it turns out that the director chooses not to defend the claim. Circuit court judgments are relatively similar in time frame, maybe 6 to 8 weeks after service of the civil bill on the owner. High court judgments, default judgments, in invariably it takes about 10 to 15 weeks to get judgment after service of the proceedings if it's not defended. If, as I say, it's simply a default judgment. How long a defended case will take to hear depends upon the backlogs in the particular court area. As you might expect, those backlogs have only been added to by virtue of the COVID pandemic. To give you an example, in Dunleary, after we decided to run a defended case, it took us 3 months for the court to assign a date. We got our date in 3 months' time. But I know that that wait, for example, then is over 12 months in Limerick City. What happens then after you get judgment, be it getting a default judgment, or alternatively, after you get judgment following a defended case? What can you do? There's actually a large number of things that a creditor that has a judgment can do that a creditor that didn't have one simply can't. And I outline them there on the screen. And I suppose if I can go through them from what might be at the start, I outline what might be the cheapest enforcement option, going all the way through to what might be the more expensive. You can publish a judgment so that it appears in stubs and trade gazettes and in certain Sunday business newspapers, the Business Post, and that will have an effect on the debtor's credit rating. You can refer a judgment to the city or the county sheriff in the given county where the debtor is based, in the hope that he can seize and sell goods to the value of the judgment. Generally, sheriffs will try to collect cash as opposed to seizing goods. Thirdly, there, you can register the judgment as a judgment mortgage on any property that the debtor owns. I suppose outside of, frequently we find that the only property that a debtor might own is indeed the unit in the development that you're seeking to collect the service charges for. And outside of publicity or deterrence reasons, it mightn't assist hugely if the debtors, if that is its only property, because you will hopefully be seeking to collect all the arrears of service charges on an eventual sale of the property anyway. The fourth one then is the installment order. That follows an assessment of the debtor's means in court, where you start seeking to obtain an installment order. The court requires the debtor to complete documents as to their income, expenditure, and assets. And the purpose of making the application is to get the get the court to order that the debtor pay a weekly or monthly sum in accordance with their means. It used to be that when that particular order, the installment order, was defaulted on, a creditor could seek a committal order, effectively asking the court to commit the debtor to prison for contempt of court on foot of that, but those have become very few and far between. An option that's open to OMCs is getting a garnishee order or appointing a receiver by way of equitable execution on foot of a judgment over assets that the debtor might have. It's often a good way of securing or enforcing a judgment over an asset or over a source of income. Say, for example, an owner debtor was selling another property. You might seek as a judgment creditor to have the purchaser of that property then pay the money to you, the judgment creditor, by way of a garnishee order, rather than to the judgment debtor. You can only do that after you've got a judgment. An asset that you might think you should be or is amenable to that kind of enforcement is where the owner has his unit rented out and there are rental payments coming to them any given month. Some of you might have heard in the past this wasn't possible. There was a case, it actually involved an owner management company called Waterside v. Kelly. It was a case way back, I think, in 2013, where the OMC's application to appoint a receiver was refused by the court. But the law has since changed or been clarified in relation to that, and there's been a Supreme Court decision called ACC Loan Management and Rickard, and now it's possible to appoint a receiver over such rents. These are the rents that the tenants that are in the unit pay to the owner. I've actually used that as a method of enforcement myself, and only in the past year or so we completed the recovery of service charge arrears to the value of close to 30 grand, I think, via the appointment. Obviously, we were able to collect the monthly rent, and it took I suppose a year and a half to collect it, but we got there. Discovery and examination of a debtor as to their means in the High Court. There's much more powers reserved to the High Court to compel a debtor to give bank account details of his assets and his expenditure, but it may not be that relevant to OMCs when the value of the debt won't reach the High Court jurisdiction to start with. But for very high judgment amounts, it can be useful. Bankruptcy of the debtor then, I suppose, is the maybe ultimate enforcement option that it might take, but that the OMC might rely upon. I tend to find, though, that the cost of doing that tends to be a deterrent to any given OMC. In the context of bankruptcy, though, and the insolvency of debtors, I just like to mention the Personal Insolvency Act and the fact that Section 2 of that Act, it made service charge debt that's due to owner management companies excludable at the OMC's option in the personal insolvency arrangements, the kind of arrangements that an insolvent debtor can apply for. That's one of very few recognitions of a special status being placed upon the debt that's due to owner management companies, in fairness to our lawmakers. And service charge debt due to OMCs is actually the only non-state debt that receives that kind of status in the personal insolvency legislation. So the OMC can elect to have the service charge debt due to it excluded from any such arrangement that the debtor applies for. However, and there is a bit of a caveat, the service charge debt will only be excluded from a debtor's arrangement if the OMC consents to doing so, or if it's deemed to consent. And it'll be deemed to consent if it doesn't reply to the notification that you'll usually receive from the debtor's insolvency practitioner within 21 days of so receiving it. So my advice is that if you receive any of those notifications from PIPs, personal insolvency practitioners, from a debtor who wants to get himself into an arrangement to have his debt written down or written off, do reply to it to elect to exclude your OMC debt from it within the 21 days. I couldn't finish a talk on service charge debt collection without referencing the Statute of Limitations. That's a piece of legislation, as many of you know, that it operates to effectively prevent a creditor from taking legal proceedings against a debtor for a debt once the debt goes beyond a specific time limit. As a general rule, service charges are subject to a statutory limitation period of 6 years from the date upon which they became due, unless the debtor acknowledged the debt within the limitation period or made a part payment as against the debt. 6 years is the standard contractual limitation period that's applicable to all contract debts. So getting the communication right at the AGM and getting invoicing right on foot of your creditor, your debtor management policy is very important. Now, I said that was the general rule. I'd always, when advising and dealing with OMCs, I would seek to try to see how many years worth of service charges we can actually go after, because if a lease is executed under seal, or you can argue that it is a deed, it's arguable that a 12-year limitation period as opposed to a 6-year would apply to that. Certain colleagues have put up the point academically in certain journals, and that Section 1810 of the MUD Act of 2011 obliges an owner in a development to pay all service charges, and that could include ones that accrued before the owner took possession of that unit. So you have that in Section 1810, but you also have Section 22, of course, of the MUD Act, which, as any of you at the talk last week will recall, that provided that service charge debt can be enforced or claimed upon in any court of competent jurisdiction as a contract debt. And that implies then that it should be a 6-year time limitation period. I've heard anecdotally that some OMCs have lost court cases or have had to drop claims for debts that were older than 6 years, based on the express views of judges in those court cases that it might only a 6-year limitation period might apply. I would have liked, I suppose, had the MUD Act maybe elevated the status of service charge debt so that a 6-year limitation period specifically didn't apply, given the fact that service charge, as I said earlier on, is a recurring debt. It recurs every year. It's worth pointing out, though, that the fact that a service charge arrears or part of service charge arrears might be statute barred, it only deprives the OMC of a remedy, and that remedy is the debt collection lawsuit. It doesn't deprive you of a right. The debtor still owes the money, and the fact that a limitation period doesn't simply applies to it doesn't mean that the debt is statutorily or otherwise forgiven or that it's written off. On the contrary, on the sale of a property, for example, the OMC is entitled to look back to many years worth of service charge arrears and seek to collect them. The last thing then that I want to take a glance at is the international picture in relation to OMCs or their equivalents in other jurisdictions. And I'd refer you back to the housing agency, the clue report that we talked about. And it looked at OMCs or their equivalent in other jurisdictions and looked at what issues they had in relation to the collection of service charges and what the sanctions for non-compliance were. I don't have time today to go through its findings, but I'd recommend that you look at it in your own time, and particularly the findings in relation to countries like Finland, the UK, Ontario in Canada, New South Wales. There's a common thread running among them, and that was that there was greater statutory empowerment given to the OMC than we have in Ireland. The OMC was able to enforce its rights, and the ultimate sanction, maybe like forfeiture of the unit in the development or eviction of the owner, was something that was open to OMCs or their equivalent in those countries. In Ireland, though, you don't have that right, obviously, as an OMC, and you can argue that the balance is skewed in favour of the owner's property rights. And I know some of you might quote Article 40 of the Constitution in relation to the dwelling at me when I talk about that, and I would accept that it may be that we have to have a rebalancing of rights if such rights are to be extended to OMCs. There might have to be the Constitution looked at. To conclude then, I just say that, as we all know, Ireland is in a housing crisis, and it's generally agreed that there's going to be a lot more multi-unit developments having to be built over the years ahead, and that means that the number of OMCs in the country will rise. Without the support and without the financial contributions of all the owners in the OMCs, like I said at the start, they can do rather little. Issues around the cost of remediation, maintenance and repair of multi-unit development infrastructure, they're very real, as you all know. Providing the services that are provided to developments isn't cheap. I haven't even spoken, I suppose, about the sinking funds and provision for those, but luckily I know that David and the guys have another session coming up on that in just a couple of weeks. Working together though, well managed and properly funded OMCs, they can do so much in terms of creating and maintaining communities and improving people's lives. Collection of the service charges that are due to the OMCs though will play a crucial role in that. Thanks.
Super, thank you very much indeed, Jason, for that technical analysis. I know there's a lot of information and a lot of meat, if you like, there for our attendees to absorb over the course of the session. So with that in mind, we will, as I said earlier, make the recording available to people in the coming days via our YouTube channel, and we will make the Jason's slides available as well. So unsurprisingly, with a large attendance of over 350 attendees, we have a great number of questions that have come in through the Q&A, and we also have questions that have come in through the through email in advance. And what I would say is that a number of the questions will be answered by the upcoming sessions over the course of the remainder of the program. So we have had questions in relation to, for example, directors' duties or OMC's register of members, and those questions will be dealt with in substantial detail at the company law session. And equally, as Jason mentioned in his conclusions, the questions around sinking funds will be dealt with in the final session, which is on the 18th of August. And equally, the sessions in relation to OMC accounts and financial management. We'll touch on a number of the background issues that are mentioned in some of the queries, and equally the role of the property management agent will be key to resolving a lot of the questions and the issues that are raised in individual estates. I'd also say, before we dive deeply into the Q&A, that we have received a lot of very specific questions in relation to particular scenarios and particular cases. And really what we would say in relation to those is that a legal advisor or a property management agent or a property professional will be best placed to provide a complete and rounded answer and advice in relation to those queries, because they will be able to review the documentation, the estate history, the parties involved. They will be able to look at the totality of the scenario or the circumstances, whereas what we have today is probably very much skimming the surface in relation to particular queries. So with that, I will look at the questions that we received on the basis of the principle that the first come, first serve. We will look at the questions that we received by email. So the first question, and I think you've probably dealt with it in much of what you've said, but we'll go through the first question is, have you encountered scenarios where a unit owner refuses to pay service charges and alleges technical or procedural defects in the establishment of the OMC or the AGM at which service charges were approved? How do the courts tend to deal with such issues being used as a defence in debt collection proceedings?
In short, I haven't had that one thrown at me, David, as a defence. If it were an issue that arose in a case that I was running, we recognise that there was a defect at AGM, I don't think we'd let it run to trial. I don't think I'd let that particular let a judge take a view on that particular issue. Generally, I find that in defendant cases, it tends to be on the basis that the particular property owner had a grievance with the services as opposed to technical issues around AGM. Obviously, it's really important that the I's would be dotted and the T's crossed in relation to the compliance with the levying of the service charge and the varying of it in any given year at AGM. And I know my colleague Nick Metcalf had spoken about the importance of complying with those provisions of the MUD Act last week, and I would recommend that you watch back the YouTube video of his talk in that regard.
Okay, next question, and again, I think you dealt with this in the course of your presentation. Can the OMC refuse the right of an owner who will not engage in paying their management fees? Can they refuse the use of the car park space allocated to their property? And I think you were very keen to stress the importance of following the, if you like, foundational documents of the OMC. So the head lease is the Bible, for want of a better term, in respect of rights and responsibilities in the estate. But equally, the debt collection policy and the service charge payment policy. Would that be fair?
Very much so, yeah. It's difficult to create a right and retrospectively penalise the breaches of it if it didn't exist at the time of the breach. I suppose it's a general legal principle anyway. But this is something that OMCs should look at, even in relation to the collection of future service charges down the line. Get your documentation right. If there's something that you want to do in relation to the denial or the withdrawal of services into the future, you may not be able to use it to collect service charge arrears, but I suppose learn from it by way of voting, get those policies drawn up and in place, and hopefully it will assist in your collection of service charges down the line in years to come, even if that right isn't in place now and you can't use it to collect the body of arrears that you might have.
And again, I suppose just to reflect on the point that every estate and every owner's management company will be different, and there will be judgments to be exercised by the OMC directors, guided by the advice of the property management agent and the OMC's solicitor. So it's very difficult to give a one size. It's impossible, in fact, to give a one size fits all answer to particular scenarios. But certainly, the directors will exercise their judgment, guided by their professional advisors. The next question then that came in by email is what is the situation if directors abandon the OMC due to service charges not been paid by some unit owners and the company ceases to operate as a company? That's probably one more for our company law session on the 4th of August. But any observations on that one?
I suppose obviously if the OMC doesn't exist, it's a lose-lose situation, in that the services aren't going to be provided and all of the owners in the development are going to be considerably worse off. I just observe, though, that it's going to be very hard for anyone to sell the property. No purchaser is going to want to buy a property in a particular development if the OMC has been struck off. That's often an issue that arises, I suppose, in developments where you've got receivers. And there has to be a restoration of the company. So it's in everyone's interest that the OMC is in existence and, as I said, is well funded.
That's ultimately the kind of the doomsday or Armageddon scenario, and there are so many things that can be done right before a situation like that can develop. And certainly, perhaps the questioner can attend the other sessions over the next number of weeks, and they'll hopefully find some information and direction, avoiding a circumstance like that materializing. Our next question, again, I think it was dealt with in your presentation. If a unit owner is, say, 10 years in arrears with service charge payments, and the only option is to engage in court action, how many years back would be taken into account by the court? And again, I think you reflected on the right versus the remedy aspect of the statute of limitations on that one.
Yeah, obviously you'd look at it to see how far back you can go, and if possible, you'd look to see what arguments you can use to collect all 10 years, particularly if you can argue that it's a deed situation where a 12-year statute limitation period would apply as opposed to the simple contractual one. Yeah, as I say, I think it covered it as well as I could in the talk. And if the unit owner is selling the property, they will find themselves, or the solicitor will find a bill for all 10 years, no doubt.
The next question that we received by email, and it came in indeed in a number of the live Q&A, is in relation to the recovery of legal costs. So obviously the debt collection process involves the accruing of legal fees or professional fees. What about the recovery of those in the context of debt collection? How does that sit?
In relation to costs, you'll remember I had said that a court case will go down one of two ways: defended case or a default judgment. If it's going to be a default judgment scenario, particularly in the district court, the court itself will mark a figure for costs. It assesses, there's a scale that it'll tell you what you're entitled to, which could be a little more or a little less than what the solicitor might charge the OMC as a client. In a defended case, then costs tend to be assessed after the case has been determined, finished up, and recovery of the legal cost will depend then upon the ability to enforce the judgment as against the debtor. You'll be using, similarly to using any of the enforcement options that we went through, you could be using them to enforce for both the principal amount of service charge and for the amount of legal cost itself. If I went to the specific example that I gave David in relation to, you remember I talked about the remedy of receiver by way of equitable execution. We were seeking to have, as well as collecting the 30k in arrears of service charge, the judgment amount, we were seeking that the the court would order that the legal costs also be paid and be collectible by the receiver after the judgment amount itself was collected, and we did indeed collect the legal costs that way.
Great. We have a number of questions then in relation to interest, and I think you dealt with that during the course of your presentation. I suppose what question that I've seen in some of the Q&As is what is the typical interest rate that you would see in a lease in a multi-unit development, or how is that framed, and what are the court's view of that?
Once it's easily ascertainable and not penal, the courts will obviously enforce it as a contractual right. The most important thing is that it is there in the lease, and that it's not. It's relatively straightforward. My own preference would be that a specific figure be there, but I know for inflation purposes, leases a link to certain bank rates, etc. As I said in the talk, I found, and this isn't specific either to service charge debt, even when you win a case in district and circuit court cases, judges tend to dislike putting the boot in to the losing defendant. They're making an order that he pay X amount, and you might apply for interest then on top of that, and in the judge's discretion decides not to award interest on your debt. I find that particularly annoying, I suppose, in the OMC context, simply because if the non-compliant, the defaulting owner, isn't paying that, his default has to be financed by higher service charges on those that are compliant.
And again, I suppose we're speaking a lot about litigation, and you did make the point in your presentation that while it is your bread and butter, ideally litigation should be the situation of last resort, really. Completely.
I suppose if you take a bird's eye view of this, at its heart, the OMC is a collection, a club, and it's a gathering of unit owners. You can't increase the number of people involved the way, as I say, a trading company could do so by increasing sales. So in most situations where you've got a club or a fixed number of people involved, the sanction with which you enforce compliance with rules is that they're ejected or they're withdrawn from the club. So, you know, if we're talking about how I'd like to see things now rather than how they are, but ultimately down the line through legislation, that's how I would like the situation for OMC enforcement to be, that there are real tangible sanctions with teeth for the unit owner that doesn't pay their service charge. There's a real effect when they are that they lose rights or that they lose privileges, as opposed to simply they don't pay their debt and the OMC is forced to call in solicitors to issue judgment proceedings against them.
Switching tack a little bit, a number of questions have come in relation to owners of units in multi-unit developments who are resident abroad. So in terms of pursuing them, either initially in terms of the initial debt collection and then in terms of litigation and serving notices on them, what's the current situation there?
In pretty much all of the courts, you are going to have to serve the proceedings on them abroad. The Irish courts, in terms of granting judgment, and the higher up you go in the court, the more difficult or onerous it becomes. You've got to prove service abroad. If they're based simply in other EU countries, you can use the rules based on European regulations for a relatively easy issue of proceedings. But if they're based somewhere like Australia or the USA, you're effectively then looking at going into court at the very outset for permission to even sue them. So the bottom line, David, as you can imagine, is that adds greatly to the specific cost of legal proceedings in those kind of scenarios, and goes back to the point then that it would really be preferable if the sanction for non-payment of service charges wasn't debt collection legal proceedings.
Yeah, again, I suppose we're in a situation with the legal framework as we have it, and I see a number of questions in relation to writing off debt and whether that's advisable. And you've mentioned that ultimately it's the case that a vendor, someone who owns a unit in a multi-unit development, wants to sell it. There are probably, that's a hinge or a pivot point, to use the modern terminology or the trendy terminology. That's a crunch point for the OMC where they have influence and they can recover the debt. Isn't that fair?
Very much so, absolutely. And as a debt collection solicitor, given that they have that particular right, which ultimately no purchaser will buy the apartment or the unit in a multi-unit development unless the MUDECT queries are responded to. It is a real weapon for the OMC.
We have a number of questions in relation to costs of debt recovery and solicitors' fees and so on. And I suppose really, I won't put you on the spot on that one, but it's probably fair to say that like any other service that an OMC is seeking from a professional provider, they should contact two or three or four different providers and get quotes for the costs involved, so that they get value for money, and that they can ensure that the relevant services are provided at a value for money basis, because ultimately it's members' fees that have been spent. One question that came in: what does the debtor need to have done to constitute acknowledging the debt?
The acknowledgement of a debt to restart the statute of limitations should be in writing. So an admission by way of email or in a letter, for example, that the person owes the service charges will constitute that. Effectively, how we often try to engineer it, indeed, as solicitors, is you would, when a person isn't paying and they may say something like they can't afford it, you would send them a statement of means and have them fill out their information as to their income, asset, expenditure position on that statement of means, and we would always seek to say, look, that in itself is an acknowledgement of the debt.
Okay, very good. Well, look, we're coming up now to 1:45. I'm conscious that we only skimmed the surface of all the dozens of questions that came in. What we would say to anyone who has sent in a question is who has sent a question in the Q&A section, the Q&A function on Zoom, is to maybe send it to us at mud@housing-agency.ie. So I'll put that up on screen. I'll share my screen with some concluding information. And apologies, Jason, that's your presentation.
Sorry, that is mine.
I've just popped up there. But what we would say to people is to contact us at mud@housing-agency.ie, and as I say, you can send your queries into us there, and we will, while we can't really provide comments in relation to the fine detail of specific cases, we can provide you with resources and perhaps a direction as to where you might find out the answers and who you might speak to. So we're going to wrap it up there. We will, as I mentioned, the slides and the recording will be circulated in the coming days by email. Please remember, if you haven't done so already, to register for the session next week, which will address MUD financial management and OMC accounts. And in the meantime, There's a raft of information and resources available on the Housing Agency's website that may answer some of your queries while you're waiting on the next session to come up. You can see our email address at the bottom of the screen there, mud@housingagency.ie. And so with that, we'll conclude the session. We'd say thank you very much to Jason for his presentation. Thank you very much to everyone for joining us this afternoon. We had a huge attendance and we hope you found it informative and educational. So we'll wrap it up there and say thank you very much. Good afternoon.
Thanks, everybody.